so we can get started. We had got as far as going through the whole step-by-step structured approach yesterday evening to where what is termed the well-founded or the risk box, as we say. Having gone through the harm side of it, the serious harm, being persecuted and decided whether or not the harm rises to the level of being serious harm that amounts to being persecuted, and thus the person can be assessed further in the refugee claim. Okay, the next step is this. As you remember from Article 1A2, a well-founded fear of being persecuted, and it goes on to 4 reasons of, which we will talk about the convention reasons afterwards. Here it was, well-founded fear. And, right, our fear is well-founded. Any suggestions? The first point that we need to make, what your understanding, I know it's in English, but well-founded, what does that immediately suggest to you as to the meaning of it? Yes? Excellent, yeah. In other words, substantiate with evidence, but it has to be objective. So there immediately is the objectiveness of the test. Objectively. And then you move on to well-founded fear. There is a real risk of it occurring. All right? And we'll talk about that more soon, because that is crucial to the decision making in the future, because, as we said before, this is a test looking forward with the crystal ball, or more than the crystal ball, but looking forward to the real chance, objectively, of the fear of being persecuted happening on return. So it must be predictive. It cannot be anything else.
May I? This real chance, this is a sort of a buzzword, I think. So, how real or this maybe how real just chance, and just chance is a chance. In the future, it's not occurred yet. So we predict, as you said, kind of a crystal ball thing. So. For instance, weather forecast in Japan. Weather forecast, the rain will maybe 30% or 10% or 80%. This sort of predictability, that is a chance, and mathematically something like that. So, what is the image of the? I hear sometime in kind of Australian High Court decision, it's kind of 10% over, maybe 10% sort of a. Rain should be rain or real as a thing. So any sort of analogy of this sort of image, or how real the chance is?
The reason for the real chance test, and it has several other names around the world that all mean exactly the same. And let's start by the simplest explanation, and which works really well, and that is it is a real chance as opposed to a remote chance, remote, speculative or fanciful chance. And so you do not use percentages because it's just not realistic. What you are doing is, on the accepted facts we were talking about that you've found, including the COI, looking forward, it cannot be something that has a high percentage requirement or as I think it's tests are used in countries like beyond reasonable doubt, etc., which is a sort of criminal test, which is utterly ridiculously high because of the paucity of information, the poor amount of information you have, your inability to give it accuracy, your inability to test, cross-examine, or whatever it might be, the people in front of you. And so you are putting together a test that gives you a real, a sort of a reality to this person's claim. All right? That's where it comes from. And all right, the words real chance did grow out of the famous case of Chan in about 1991 in the High Court of Australia. And even in that case, or certainly in American cases, they have said the classic situation of, right, there are 10 people on the bus and you are driving along in deepest Syria and somebody comes along and they're clearly some form of terrorist or government person. They come along on the bus and they say, I want to know who are members of the terrorist clique or the opposition party here on this bus. And until you give me the answer, 1 in 10, one of you will be killed every 10 minutes. You are one of the 10 people on the bus. Do you have a real chance of being shot? Please give me your answer now. We'll go round. Starting with Sato Sensei.
Yeah.
You think you got a real chance? You think you're a real chance? Anybody not have a real chance? See, even the photographers agree. But there's the simplest test you can get. You see, it's the reality of the totality of the evidence. And that is your job as a decision maker. So when you see tests such as people adapt from common law or even non-common law situations, and they say, oh, it has to be beyond a civil test, for example, which is the balance of probabilities, more likely than not, 50%, in other words. It's 51 or it's 49. That, when you come at the test we've just been through, clearly is not a real chance. It is above a real chance, you could say. So the other term that's often used then is the lower standard. If you want, that's what they use in Britain, where they're really stuck on these chances like beyond reasonable doubt for criminal cases, or sure, as we now say, or balance of probabilities, or more likely than not tests. You see what I mean? So it therefore needs a test which is different and really can go to a lower level than the balance of probabilities, the civil test. Yeah. It can go below that because of the reality, the paucity of the evidence that you have and that you're looking forward. And all these things in a country you know nothing about, with evidence you've obtained by interpretation, by the paucity of knowing whether the interpretation is good, by the relying on COI, but it's not guaranteed. Now, all these things are what you have as the evidence in front of you, that bundle of evidence. You exclude the part you have not. If you've accepted all or part of it, and then you go on to apply your test. And the test, therefore, is now widely spread as being real chance, otherwise called reasonable likelihood in Britain. It's called, it's a very similar name, reasonable, the US test is again almost identical. The European test is very much the same, although the Europeans say it's a little more than real chance, but I don't know what that is. But I think that comes down to the whole nature of civil law jurisdiction, which goes back to the sort of old biblical thing that you were appointed by God and therefore there was you had some sort of brilliance in your mind that allowed you to determine it. But leaving that to one side, not many of us are so well inspired or allowed. So the atheists of the world amongst us have got to come up with something a bit more with reality.
So is it true that this real chance test is maybe the less likely than the likelihood or probability test? Probability test is a civil justice.
Yeah, well, it can be.
Yeah.
It can be. You can have other cases like we were talking about the Eritrean woman or something like that yesterday, where the chance is probably 99% or 95%, as we said. And you know that from statistical evidence.
I think one of the reasons why Japanese court very strict for that decision is based on that the civil justice test. This because this for especially administrative litigation, the refer to the procedure rule for the civil procedure rules. So in the civil procedure rules, definitely this balance of that is a probability test.
Yeah.
So in this sense, they think the same sort of mentalities so decide refugee or not. So I think this is a key for the real chance.
It is, and it's well, as we'll be talking about the cases in the next course, it is on a comparative basis with virtually every country in the world. It is not a test that is applied of the balance of probabilities, or more likely than not. It's not the civil standard, it is this real chance standard which allows you, on the totality of the evidence, with, as a famous British judge called it, no probabilistic, in other words relating to probability, cut-off point. And we talked about no litmus test the other day. These are just English ways or chemical ways of putting it. So there is just not that degree of certainty, and it comes back to, we were talking about before, the rather unique nature of refugee law. And so this is not civil law. This is not a situation where all the evidence can be brought before you and you can get far more certainty in and accuracy into your decision making. This is not a criminal case. The people are not criminals. And so you have to realise all that and make your decision accordingly. It, coupled with that, something that we always try and do in training and do too, is a good, healthy refugee determination system will also have in it a cancellation provision. That if you do get conned or you do get some excellent fraudster put a story across you, and you later determine, as quite often will happen when they suddenly produce a new passport that's valid to the country they came from or something like that, and they go back to see their friends or find a wife or do such things, then you are quite right to bring that case back, and it must go through a fair process, to look to cancel their refugee status on the grounds it was obtained by fraud or something like that. So a healthy system, like all good systems, has balance. Okay? So occasionally you will be conned, to put it, but you will be taken for a ride. I don't think in the sort of, I don't know, I probably went through 10,000 cases, but about 3,000 or 4,000 I would have actually heard that, and maybe that's just luck, I don't know. I've never been had a case cancelled. I think in New Zealand the percentage, and it is, it's done there, in fact done probably more than most countries, cancellations. And it's about, or it'd be less than 0.5% of the cases. So is it better to get 0.5% wrong and save the lives of 99.5% of the people who come? Or should we start cancelling them by putting a ridiculously high hurdle for them to climb over, or a number of hurdles for them to come over? That's the bottom line. when we've been through all this. This is meant to be humanitarian, the preamble, all these things. Anyway, this is the key to it. And again, if you want to get the cases right, this is the experience now of some 20, 25 years of using it and sticking to these principles in your decision making. So, the test is objective, not subjective. Is there anything that, if we realise that if a person's made a claim, then clearly their subjective fear is dealt with? That's it. Otherwise, why would they make the claim? It's as simple as that. Everything else is objective because the objectivity goes back to, as you said, the well-founded fear. And so going on about, and a lot of jurisdictions in the UK, there's a bit about, subjectively and objectively. There's no subjectivity in it, or otherwise there wouldn't be a claim. You've got over the subjective bit in 1 minute. So it's because even where there are subjective predicaments of people, they've got one leg, or they have other vulnerabilities, or what have you. It's an objective assessment of their subjective situation. It's still objective because people notice them. That's objective. Everybody who's got one leg is noticed. And so all those sorts of things are objectively able to look at. You don't need, it's sad that their subjective situation may raise their profile, but that's an objective assessment of their subjective situation. Do you understand me with that? Everybody's nodding their head? Very good. So, the degree of risk is measured by the real chance test we've just been talking about, and the decision maker's gaze, which is a good word for it, looking forward, is prospective. The relevant date for assessment is the date you make the determination, looking forward. Okay, and this, as I said, if you are too slow in making your decisions, as I said, there is actually law in Britain, if you don't make it within 3 months, which is easily too long anyway, then you have to do the case again, because the world has changed, and changed radically. So, as I said, subjective fear. In order for a fear of persecution to be well-founded, there must exist a danger that if the claimant for the refugee status is returned to his country of origin, he will meet with persecution. Refugee conversion does not enable the claimant to decide whether or not the persecution exists. That's subjectivity versus objectivity. It goes back to 1988 in this famous case of Severakumaram, which was really one of the early builders of the whole refugee determination system. An objective test is principled and defensible. Subjective depends on the individual too much, and a subjective test is actually incapable of assessment. How do you know what's in somebody else's brain? You don't. The objective standard gives a measurable degree of reality. So Hathaway and Foster, in that book I had here the other day, persons facing harm should not face differential protection. That's what we've been talking a lot about, getting consistency. Okay, I know in the real world it doesn't happen as one would like it so much, but that's what we should be striving for, not based on somebody's own individual temperament or tolerance. This is an implication of giving substantial weight to the appellant's fear, which is wrong, subjective fear, and the central issue is whether or not an individual can safely return to her state. International human rights standards are common to all, and that's the key point. That's why we use them, because then you end up with a measure everybody understands, an objective measure that everybody understands, or is capable of understanding by just going to the relevant material and the relevant human rights standards. All right, so any questions on that? it's fairly clear, I think. Hathaway's, with the help of Michelle Foster, has been a lot clearer in his second edition than his first one, I always think. Past persecution alone is not enough, unless you're in America. And we talked about the Cold War built into their legislation. So all you had to do was get across the Berlin Wall and you were immediately a refugee. Well, you probably were in those days, but I mean, that, and continuing that on after the Cold War is rather stupid, but anyway. The central issue is whether the applicant can safely return to their state, thus it's forward-looking for the assessment. So past persecution, even objectively established, does not suffice. It may, however, be an excellent indicator of what will be the future harm. All right, so it's a good indicator if you've been persecuted in the past, but let's say the problem is, your claim is a surplus one that's arisen since you arrived. Well, it won't be there, will it? Logical. So but it is often a good indicator, and therefore, in the assessment of cases, people will look to see whether they've got it. And often there were things got a bit ridiculous with some things like Sri Lankan cases where they were looking for scarring and certain things that happened to Tamils who had been persecuted by the Sinhalese during the war there and so forth. So that's that's a New Zealand case. I think I might have written that, but anyway. So the real chance test, the real chance test is less than the balance of probabilities, what we've been talking about, more than a mere possibility, remote or spec. This is the way I always used to do and come out of every decision when you put the whole lot together. And we always tried to have in our retiring rooms, not in more in New Zealand, but in the UK, this sort of whiteboard, quite a big one, and you would write up, particularly if you're sitting with somebody else, you'd write up all the points on there of what you found and try and, so you're getting the totality of the evidence, and then say, right, because you've got to give reasons, and you put the reasons up, and we were just talking about it earlier today, Sujin and I, and sometimes you do that and you think, ooh, there's only about 2 reasons here I can actually substantiate. Is that a real chance? And sometimes when you sit down and go through that immediate reculation after your assessment, whether you're an officer or a court or what have you, you may not find there's enough. Or when you go through it, you may find, ooh, this is really at a high level of chance. So therefore, my reasoning is, but it's a very good test. And so we used to often do real, remote. And so you go through that sort of score sheet. It's just, these are all just things to assist people in decision making. And that's why I love these big whiteboards, because you could, and do it for yourself as well. And so you can then visualize it in front of you. You can look back into the notes you might have, you look back into the COI and so forth, and double check yourself. If you're smart, in most cases, you will do that before you end the case. In other words, you take a short adjournment or a short break, 10, 15 minutes, tell them to have a cup of tea or whatever you're going to do, and then come back into the hearing room. And if you discover from that withdrawal, particularly if you're not adept at doing these cases over a period of time as you're building it, go away, think about it, think it through. Now, are there any questions in that time, particularly on credibility or so forth, or on chance, that you think you haven't answered? Go back and ask them. We talked about hear the other side. It's your chance to do that and to check those things and to get and tease out and find those answers, all right? To make your decision better, to make it more reliable and to confirm or otherwise what your conclusions are going to be. So it's a very wise thing to do, to take a sort of time out and check it out. And so it's just years of experience doing it that way, even when you're sitting alone. make sure you do it, because it, and if you're an officer doing it, just say, right, I'm having my cup of tea, or I'm going to do this, that, or the other, and go through that assessment of reality or possibly credibility points. Any questions on that? Or it's fairly logical when you think about it. It's not capable of a precise, or as we call it, bright line in the sand type of thing definition, nor is it helpful to talk about percentages for the reasons we discussed earlier of the man or woman on the bus. So that's it. It's real chance equals substantive, or substantial not remote. So it's a fairly substantial chance. You're not going to have ridiculously, sort of less than 1% things, but most of the chances, if you're looking at percentages, that sort of 1 in 10 thing is going to be very much at the lower end of the reality.
Yeah, because there's just the analogy of the weather forecast, you know, when I get out of the home, I just check this news, weather news, and maybe 10% maybe just prepare. So this is a real thing. So.
Well, we were just saying that as we looked along, I think the forecast today said about 30% or something. So they were 70% wrong. So the origin of it lies going back substantially. Allan Mackey was he was sort of the forerunner of Hathaway and Guy Goodwin Gill and Michelle Foster and people, the other great academics in this field. And he wrote right back in 1969 that a real chance of assessment, the likelihood is there a real chance he will suffer persecution that is reason enough for his fear to be well-founded. Actually, and funny enough, today I was looking for we're looking at cases for the next, with English translations of them, for the next course. And I came across a Bangladeshi case which is written up in the International Law Association reports, which are well translated, I say, very well. And in this case, the judge had, by a route that certainly didn't follow this one, wandered around the road, as I might say, or wandered around the path, and come up with a decision where I think quite rightly had found the person to be a refugee. But he or she or there were three judges in the district court here at Tokyo, had concluded that there was a real danger. So it's almost the same, it's just similar words. I don't know what it was in Japanese, but certainly that's what it is. So even though the civil standard and all the rest of it here, and the Administrative Litigation Case Litigation Act may say, well, it doesn't actually say, it just leaves a lacuna, in other words, a hole in what the test should be. And these judges had filled it in. I don't think they actually knew they were doing that, but they've said there is a real danger. He did say later on that it absolutely would happen, but so you can see the lack of not having clear guidelines like a real test, a real chance, had at one stage been found to be a real chance, and another way to be absolute. So, and then a lot of the reasoning goes on, well, this may have happened, and I cannot be sure one way or another, and this sort of thing in the evaluation of the evidence, which we talked about before on credibility. We need to have an established, accepted set of facts, of characteristics we can then take into this box and assess the risk. Not bits and pieces where you're not sure, or you maybes or anything else. That's not what you're there for. You're there to assess it. That's what a judge does. Okay? So, yeah, so that's that. It is not to say this will be easy. Cases, in all cases, it will not be. And I tell you, when you're first doing it, particularly, you lose a lot of sleep, particularly when it comes along with all the traumas and everything that go with it. It's not good for your sleep patterns, some of the horrific things that man does to man or man does to woman or groups do to other people. It is inevitable that difficult judgments will have to be made. That's an Australian judge in this famous case of Chan, which is the highest court. The High Court of Australia is the federal court for the whole of Australia, not a state court, but a federal court, and it has, well, you've seen them in action, some very, very good judges and very, very brilliant Chief Justices that they've had in Australia. So there's very, don't get me wrong, it's an extremely reputable, one of the top 10 courts in the world, really.
A nice building, nice beautiful building.
Beautiful building, beautiful building.
Transparent,
yeah,
very transparent.
And it's interesting that the highest courts in so many countries now are moving in that direction. Now, they were one of the first. In New Zealand, they have just built a new Supreme Court in Wellington, probably after your time there, and it's again not huge, but a smaller, and it's right in the centre. It's across the road from the Parliament, and it's a quite magnificent piece of architecture with artistic bronze carvings all around the outside of it. But when you sit in that court, you sit, there's about 7 or 8, 10, I think it's about 7 or is it 9? 9. 9 is the maximum bench they can get. And they sit on a sort of semicircle, not quite like me, but with a suit and tie, no gowns, no wigs no wigs. And so they sit like that. And if you look out, it's on the ground floor, or the first floor as you would call it. It looks straight out onto, it's called Lambton Quay, one of the main streets. And people are walking up and down there, doing their daily business, and they can literally look straight in. There's some pretty good bulletproof glass and everything in between them, but you can sit there. So the Chief Judge, probably 50 metres, 70 metres away, can almost look you in the eye and so, what did I say yesterday about justice? Seen to be done, literally seen to be done. The Australian one is pretty similar, and I don't know if you again watched on TV in the converted building that they put the new British Supreme Court in, almost the same thing. You could see, and everybody could see, it was on TV as well, the same thing happening, President of the Supreme Court in open court delivering open justice. And so clearly in refugee cases, not quite so easy as that, because if you disclose who it is or their family or anything, you may immediately put them at risk. So we'll talk about confidentiality. So it's not a good idea to do that when the ambassador for Iran or something is just across the road. I'm being ridiculous, but you know the problem. The last thing you want to do, which is the reason why, well, they used to give their name in those days, that's why that's stopped. You'll see nearly every court now, you'll see the New Zealand ones just had numbers, because a few people even complained when we used initials. And so I said, fine, we'll just have a number. The problem with the numbers is they immediately become forgettable. And so you'll see now in UK and New Zealand, and I hope it's one thing that I've helped with because it's been at my insistence in both countries, we use things like, this case is called LP Sri Lanka risk on return or something or other like that. Or the cases in New Zealand simply have numbers, so letters. So the first one for Sri Lanka will be AA Sri Lanka, and then it will have a number after that. So, and then the next one is AB Sri Lanka, and then it goes, AA Bangladesh. And so you've got AA, BB, so you can do a lot of cases. And so they're all identifiable. So that some of them become, one of the most famous cases now in New Zealand is called BG Fiji. So you don't, about climate change. And so you don't forget that in a hurry. Whereas and that's why when this Sri Lankan case from last year here, I've, for the purposes of calling it BCD Sri Lanka, because it talks about binding nature, it talks about cessation, and it talks about declaratory nature. So let's term it. It's nothing to do with the name of the person, but its usefulness is for those three things, and it's about a Sri Lankan. So that's the sort of thing, and you'll see all the country guidance cases and the published cases in UK now have random initials. I would strongly urge, if you talk to judges here, don't call everyone X versus the state. Yeah, that's all in X. So it is utter lack of memorability and utterly useless, even though you don't have a precedent system, as a term for one case to the next. So you're having to go through, it's that Sri Lankan case from the 5th of December in the Tokyo High Court, this, to remember it. It's not helpful. Okay, so this has been debated academically by some of the brightest stars at the academic and judicial and other levels, getting together in Michigan, thus the Michigan Guidelines. They are chaired by James Hathaway. He started them about 2001, I think, on who was talking about internal protection the other day. That was the first set of guidelines, which we'll come to in a minute, actually. And so he's now had about 14. I had some a book with them that'll hold it up to about 2009, but he published his book with them all in. So in New Zealand, as an example, it's adopted the Michigan Guidelines on well-founded fear. So that was one of them. And he gets about 20 people from all around the world. Have you ever been on? You haven't. You should. They should send you sometime. Hathaway should have got you after doing all his work for him. My God. And he's never asked me either. But no, he's a famous academic and judge in New Zealand. Roger Haynes has been several times. A lot of top Australians have been as well. So anyway, they adopted these, I think fairly early on, maybe 03, 04, something like that. The uncertainty inherent is in the forward-looking risk, consistency with plain English meaning and the dominant French meaning, the internal structure of the convention and human rights approach, all right? The assessment of well-foundedness is purely evidentiary in nature, and there are significant shortcomings in all assessments that go forth. All material evidence from whatever source must be considered and taken. That's what I was talking about, the totality of the case. Past persecution is relevant but not a prerequisite. The applicant should make the best efforts to provide supporting evidence, but an assessment of well-foundedness may need to be based largely on, or sometimes solely, on the credibility of personal testimony or evidence. So this is very important because there are plenty of cases. You tend to get more evidence now because of the internet, because you can get a lot of COI from what's going on in downtown Mogadishu yesterday type of thing. So you couldn't clearly, we used to collect, when you came to New Zealand, we had, you know what an East-like box is, these boxes where you put it, and all had clippings from newspapers and all this sort of thing. That's the way, when I started, you got COI. And so you put them in The Economist and various articles and as I said, Human Rights Watch and these things, but that's all you had, plus their own testimony. It's one of the reasons why, I don't know what happens here, that it's considered a good practice. I know it's, for people to swear their evidence, either on, the Bible or the Quran or whatever it be, or if you're an atheist or a agnostic or whatever you might be, to just affirm. In fact, in New Zealand, most of the time we ask people just to affirm, because then it covers everything. So, and just to give the whole thing a note of seriousness. And the interpreters are also sworn in as well for the same thing. That's what, it's old law, but that's what makes it testimony as opposed to just evidence. It's something that's meant to be taken extra seriously. It is not binding, or the real chance thing, but it's looking for international harmonious meaning. In other words, everybody does the same. Created by a colloquium of, well, this is one, leading academic minds. That's pretty good to call themselves that. It's principled, and it has strong adherence to the human rights framework. Objective standard of fair, forward-looking, real chance test, not speculative. Summing it up.
What is the New Zealand view?
That's just the New Zealand view that I'm saying about that's the way we apply it in New Zealand, put in the simplest of forms, okay? Okay, an objective standard of fair, it's forward-looking, the real chance test is applied, and it's not speculative. So, in other words, if it's real chance, it's not speculative chance or remote chance. That's putting it in the simplest of terms you can put it.
Just to summarize,
That's a summary.
New Zealand practice.
Sorry, it's just overview or whatever you want, maybe views too. But
no special guideline or handbook of this sort.
It's in plenty of decisions, decision after decision. So when you've got about 7,000 or 8,000 decisions saying the same thing, and the highest courts in the land approving that, then it's the law of the land by that stage. And it's not just the law of New Zealand, because as you saw, it's the same test in Australia. It's almost the same, it was the same test in Canada, till the Canadians strangely wandered off the path on requiring a probability test for the credibility, for the acceptance of facts. So they have a double standard now. So you have instead of looking at totality, they look at the credibility or the finding of the facts have to be established on a balance of probabilities basis. Having established that, they then apply a real chance test to the risk. And sadly, that's what's driven, when you look at it from outside, and most people now agree, it's driven Canadian law down a big hole in the road, where it used to be a leading, a lot of the leading jurisprudence came out of Canada, Ward cases and some of these cases, famous cases, and that's how people like Hathaway, he's a Canadian originally, started, but they got themselves, I think about 10 years since they've started applying that test. It hasn't helped them at all, it's made it far worse, and so the respect they had as the leader in it has gone, which is unfortunate, but that's a reality. Okay, so that's the next one. Anyway, that's well-founded to your risk box. Any questions? Anything of concerns? Do you think it's a correct way of assessing somebody's risk on return? Well, I hope you're not speculating. That's the whole purpose of it, to give it, to say there's a real chance, and come back to what we looked at before, where we looked at the term being persecuted, which personalises. It's not, yes, you're quite right, you can have situations where a state of persecution, plenty of persecution is going on, and that's why it is utterly wrong to use the word persecution as a noun, going back to persecution. No. The test is being persecuted on return, a well-founded fear of being persecuted. In other words, you. And so that means you've got to look at the personal predicament of somebody of their nature, or with their characteristics on its return. So objectively, does this person with this with a summary of who they are, will they be at a well-founded test? Now, there may be, as you say, lots of persecution and problems going on in their country. They may be in a situation where they're not affected by it. They may be, because of that, an objective assessment of their profile, they're at a heck of a risk. Or they're on that sort of cusp between real and reality, and that's your job as the assessment, or that's your job as counsel to get them over that line or over that situation so that judges or assessors will reach that conclusion that it's a real chance, not a speculative, frivolous or other minimal type of chance. All right, does that answer what you're getting at? Yeah. Because, this is right. There are countries, they're pretty disastrous and all sorts of problems, but you assess taking, as I said, these were quite smart people, 50 or 60 of them, and a whole lot of other NGOs and governments and so forth in attendance back in the late 40s and early 50s that put this together. And it is, they're pretty smart people, and they didn't miss too much, which in some ways is not surprising because they just had about 50 million people displaced around the world and been to the most horrific 2 wars over a period of 50 years. So, they had a lot of time to think about.
But still the sort of a real or remote or speculative or substantiation, these are still some sort of a subjective things. I mean, they kind of depending on the decision maker's sense of the, based on the experience and so on. So I think it's not so easy, I think, unless, the decision maker experience in this similar situation or kind of a something, because I don't think everyone just thinks same in this sense. Someone will be very much, covered, or someone is a bit broad, or these are the personalities also reflecting in this kind of decision. That is maybe some question probably.
That's a good question, but as I said before, you have to give well-reasoned decisions. What is the value of the decision if you can't make it stack up, in other words? So what Sato Sensei says is right. If you just sit there and you hear some case and you don't refer to the COI, you don't put the effort into finding the person's story and what's acceptable in it, and you don't look for comparative cases, then you are putting yourself in the situation where you may as well flip a coin. And that's not the job. So that is why we talk about having reliable COI. And now it's brilliant. You can get huge amounts right up to the minute from the internet on the general conditions and what's happening, and specialising in particularly people being maltreated and that sort of thing around the world. So it's not, with great respect to Sato Sensei, you are not in the situation, if you do the job properly, you're not in the situation where you're just flipping a coin. You have reduced that as much as you can by, even if it takes 2 days to interview the people, even if it takes a longer time, it's worth putting in the effort to get it right first time, as I said before. It is worth having COI like the CDR and all these, having small offices like that our good friend is setting up here, to get all that information, to share it with the others, with both parties, and to then bring that all together in its totality and then to make your decision. So the whole effort is to take your decision making to the highest level with the best evidence possible. So we don't flip coins. So we're not left with virtually nothing. And even when you get cases, as I spoke a bit about yesterday, where the person has lost their mind or they've got problems for that, you then go, it talks about it in the guidebook, in the handbook from the you look at the totality of the evidence around them that happens to similar people. That's why you've found the sort of profile of the people. That's why you do that. So you can then look at all that, and all right, it's not going to be as good as having somebody whose own mind you've been into sort of style, but it does give you a tool. And after all, in the end, you're making a humanitarian decision of life or death, being persecuted or not being persecuted. Can you tell me any more serious question than that? You can't. And so that's why, in the end, you need the best information possible. You'll never be perfect. And that's why it's a real chance. It is not a criminal case where you can get everything before you. It is not a civil case. And any state that drives it through a civil path is doing the wrong thing. It's using, as I talked about before, you're playing with the wrong rules on the wrong park. Okay? So, because this is quite unique. And it does. You'd be quite right. When I took this on, and everybody I've had the experience, takes you quite some time to get this into your brain, particularly if you're a lawyer, when you've had that sort of degree of certainty, or trying to get the degree of certainty into the cases before you, and insisting on you get it before you decide guilty or not guilty or whatever. And the same with juries. If you don't give the juries the information, or what do you call them? Sanban-in or something here now?
裁判員
裁判員, yep. If you don't do that, then don't expect them to make good decisions. It's the same thing.
Here.
No, sorry. The Michigan guidelines themselves don't hold themselves as out being binding. We have adopted them into New Zealand law, so they are virtually binding now, all right? Yes, write it in your decision. You know, you can go through in your decision and you say the judges below you in a precedent system are bound, and your own court, if you set it up in a manner that it is clearly meant to be binding. You understand what I'm getting at? And if it's found, if somebody disagrees with you, or the Crown or the state disagree with you, they can take you on appeal to a higher court to say, and this is what we were talking about yesterday, this decision contains a significant error of law. They had no right to adopt the Michigan guidelines because ABC, all right? And they will argue that before the Court of Appeal or the Supreme Court I was talking about before. And they will rule whether you're right or whether you're wrong. In the Michigan guidelines case, it's never been taken on appeal. So it becomes binding even at the lower court level, because nobody, because it makes sense. and why would you want to appeal? Now that's the technique, and in different countries it will have. In non-binding precedent countries, it won't be quite the same as that, and there will be more sort of flexibility, and so it'll become more of a guidance type situation.
Yeah, in Japan, we are not common law jurisdiction, but a Supreme Court decision were binding. The judge is anyway but not kind of a sort of a law. In common law style, the judges find the law, find the binding or not. So this decision is quite much binding the other.
There's the ratio decidendi of the case is binding on people below you, but that just means the most important parts on it, and then other parts, so-called obiter, outside the key points are not binding. And so anyway, I won't go into the whole of the common law with you, but basically, in fact, it's very interesting. It's very interesting working in Europe. And one of the strange things, just as a slight aside, on the European Union, in the sort of 25, 30 years that I worked, because I was there in the 70s as well, the impact of the EU caused by the British justice and Irish justice, which both work on precedent systems, on the rest of the EU has been quite substantial. And so now what you're saying is cases that are of a important and binding nature are far more used across the whole of Europe. And so that we had a few years ago, you may recall, he talked about it, Harold Dulig, who is on the Supreme Administrative Court in Leipzig, in German, in other words, the top German court, was here, and very interesting because the German sort of base to your system. And he was saying that their decisions now are pretty well absolutely binding on the key points through every German court, apart from they have a different constitutional court system there as well, apart from the constitutional court. So quite interesting, and that is really the amalgam or the coming together of European systems, which is one of the reasons I just cannot work out why the Brits would ever want to leave, because it's their law that's being adopted, or more and more from, because they've had a precedent system, so they've got the tools to use, and the Europeans, not totally, but are picking it up more and more to apply the same thing. Certainly in the Netherlands and Belgium and Denmark and Sweden and Germany, the northern part, that's happening and was happening. And so, as I've said to many, and a lot of my European things is, state, if the Brits, the UK people, cannot win arguments using their own laws and their own language, you've got a bit of a problem. So it is therefore amazing the Brits would walk away from the EU when they are clearly the most significant, particularly in the law, influence on the whole of Europe.
Yeah, UK is very complicated. I think Scotland is not common law. This is continental law. France.
It's sort of halfway in between.
Halfway between.
Yes.
How about Ireland?
Oh, Ireland is purely common law.
Common law.
Yeah.
Not only the Northern Ireland, all Ireland itself.
Islanders, yeah, but the whole of the south.
Oh, I see.
Ireland on the island of Ireland, yeah, which is always difficult. But no, in Dublin, the court there, and so you could sit there. In fact, one stage they asked me to sit there because I have Irish nationality, and I did a lot of training there, and so there's plenty of Irish cases. They didn't, the Irish didn't get it by desire. They got it because the Brits told them to do it. And the whole of the legal profession, as you're probably aware, and anybody, the ascendancy, if you want to read some Irish history, was just told, the poor bloody Catholics, that they would do as they were told. And so that's how it came about. Okay. We've done enough on that. Time is called. Very good. So there's a few little pieces to finish, and we're going on, as people have asked me a few times, about nexus. So you've got all this, we've done all this, that's fine. But is it for reasons of one of the 5 reasons that's in the convention? So have a look at that, have a think about that, and we'll come back and do it. What we'll do, I'll also hand out now, Sujin will hand out the first 2 pages of the Bala case, which we'll try and do in the last hour here, and have a look through. Don't get too carried away when you come to do it. I'll give you another 10 minutes later to think about it. You've had the chance, hopefully, to look through the International Crisis Group. Okay, so if you've done that, we'll go through it. Don't. This is just to make you see what a case looks like, and so we'll distribute that for it. And we're not making points or anything else. For the students that are here for marking purposes, we'll give you tomorrow. Was it? Tomorrow later. Yeah. We'll send out to you 2 other cases, one on Malaysia and one on Fiji, and you can give us some bullet points. 1,000 words or so on it, on what you think and why that person is or is not a refugee. Okay.
All right, have a 10-minute break.
10 minutes, good.